Understanding liquidated damages provisions and how they can help your contracts along and how they can help your business. We recently did a shorts on liquidated damages here on the channel, and today I wanted to go a little bit deeper for people who are interested in it. One thing you'll notice if you've been checking our channel out, if you've been watching our video postings, YouTube, Facebook, TikTok, LinkedIn, we often do a short on a video, and then we'll come back and do a longer version of that video so that we can go in more in depth. And today that's exactly what we're going to do on liquidated damages provisions. This can be a very powerful tool. One of the big issues with contracts is damages are uncertain, right? We don't know exactly where things are going to go in the future. So if a contract gets broken, we have to figure out what the damages are. What is the consequences of this? And in contracts in general, one of the principles courts will often apply is you want to put people back to the place they were had the contract not been broken. If the contract had been fully performed, the whole chain of events had happened, where would each party be? That person who is non-breaching, the person harmed, should get money or other things to put them back where they should have been if that contract had gone through. That's the general concept in contracts. Well, how much money that takes, what that looks like, how you put the pieces back together again is a real question. And in some litigation, you can spend a lot of time on what folks call the damages phase, just working through how much money was lost, what did it cost, what were the downstream effects, etc., etc. Liquidated damages provisions attempt to put this all in a nice little bow and put a dollar amount around it. Courts will generally uphold that if it's a reasonable estimate of what those downstream damages might be in the future. So a couple different tests there, right? You have to have the liquidated damages clause in there, and it has to be a reasonable estimate of what those downstream damages might be based on the time the contract was entered into. So if you start putting all those boxes, and it might vary a little bit from state by state based on case law, so you're going to talk to an attorney in jurisdiction. But the idea is you're putting dollar amounts on it now. This should, in general, shorten litigation because you're not going to have that long damages phase about the amount of damages. And it also gives people certainty. They know what the risk is. They know what they're getting into without having kind of this amorphous potential damages, which could become huge. You are now putting it down to a dollar amount. So they're very powerful tools, something I think you should certainly consider in your contracts to kind of get a good idea around what your exposure is. If you have questions about business and business law, we welcome them here. You can drop video topic ideas and general questions below. Sometimes we create videos based on audience questions, but your questions are not confidential, and it's not attorney-client privilege, and it's not a place to get attorney advice. So keep your questions general, maybe topics for future videos. For specific questions, reach out to an attorney of your choosing. And I hope you subscribe to the channel so you can see more of those shorts and those long-form videos covering various different topics coming up in the future. Thanks for tuning in today, folks.